So yeah, today tower right. Okay, 7. Sean, can you read it? 7.1. Yeah.
7.1, the seller represents the warrants to the buyer that no spouse has tower rights and authority. To apply, the seller will have the non-owner spouse sign the contract, provide a complete tower concept and acknowledgement from a form to be attached to and form parts of this contract on or before. If the seller fails to provide the completed dower consent and acknowledgement form by the agreed date, the buyer may avoid this contract at the buyer's option by giving the seller written notice. The buyer's option expires when the seller delivers the dower consent and acknowledgement form, even if delivered late.
Okay, yeah. So dower rights. Who can answer me when the dower rights? When we need the dower rights signed?
So if the land title only has one person's name,
yeah,
and if he or she is married,
yes,
then you need to confirm the dower rights.
Right. But if it's divorce, if they have already divorced, then no need dower rights. Right. Yeah. So only if it's still in the marriage or common law. So in Canada, we if you stay together over 3 years, 5 years, we consider same as a marriage.
Okay, so common law also counts.
Common law, yeah. Some more ridiculous example is like I remember one lawyer really liked to say the story about like they went to Las Vegas drunk and they just married. And that lady may come one night, then she has dower right, but because they register as they're married. Okay, so if we see the land title only one name, so we need to be pay attention and ask the other party, is there a dower right? Okay. So the non-owner spouse need to sign this contract. That means the person who is not on the title, she need to sign. Dower rights doesn't mean it's a right, doesn't mean dollar money amount.
Right.
So that's what people would think, okay, I got dower rights, so I got 50% from the house value. No, it's just like you have the right to live there and to refuse sell. But it doesn't consider money because that go to the court to decide.
And the question is, so if the sponsor, the non-owner spouse has to live there at least one night to have the dower, right? Actually,
one night is more like not
it's very tricky.
Yeah, right. It's like they use the example, but it's not real. It's like you're married.
Okay.
Yeah, we don't say when.
Yeah. But
if they can prove they stay in that house.
Okay.
Yeah.
So if they're married, but the non-owner spouse never lives in that property.
Right.
So she or he doesn't have dower.
The dower right still, because if she never live there, it could be a investing property, not resident primary home. Right. Then she doesn't have the dower right.
Okay.
So, for example, if you really want to avoid your property be split or have a dower right to the other your girlfriend or wife. Another way is most chances happen to mother want to buy a house for their son, but they worry, in the future if he and his girlfriend separate, the house the wife will get the half of it. Then I would say if you want to avoid that, you put your name and your son together in the house. Then and when he married, this is more like your joint. One is joint venture. One is what's the other one? Tenancy. Yeah, in common. So if the mother put her name and to the kids and they marry and the name's still there, then tenancy in common. So it's not joint tenancy, but it still have a dower right. Dower right. No, that one is more like an investing property. Yeah. It's not their primary home. So dower right only happen in your primary home. So people like they purchase Airbnb in Camel, and they see one name on the title, say, do you have a dowry right? They don't need it because it's investing property. It's a short-term rental. It's not for long-term. So impossible have dowry right.
So the property for rent or for investment,
no dowry right, because that's not primary home. Dowry right only works on your primary home. Yeah.
But if they said even they have the primary home, the second home they said it is also for their use only, but lost for business or investment?
So we only consider one house as primary home. Even though you say, okay, we spend holiday there, it's still our home. But on the tax or we only can have one primary home. So next house, if you make money, you pay tax, capital gain. But only primary home, you don't need to pay. So dowry right only also used on the primary home. Okay.
And so in that case, so mother and son, they like joined in common on that property. And if they live in as a primary home, and the mother has sponsored, the son has sponsored, I mean, does those sponsors have dowry as well?
So if mother and son register on this house, and this is not their primary home, so that's considered investing.
Okay.
So
what if it is a primary home for them to live in? And
primary home, but it's not. That's a good question. Let me think. Because
yeah,
because both
sides has
both of them have dowry. That means two dowry.
Right.
For the primary home is you have to live there for like 1 year. Is it?
It's not 1 year. As long as you have a mail tax or any mail utility bill, yeah, it could be 1 month. Yeah, but right now the 1 year thing is a new policy about the tax. If you live less than 1 year, you will be taxed higher because they think you are use your primary home to making to flee. Yeah, so they. But I think that's BC. Here maybe not yet. Pretty soon. Okay, any question? So normally we put if we put father, son, and it's not couple, it's not the red family. It's kind of you won't be joint. It's not joint venture. Sorry, not joint tenants. Yeah, that one is the huge difference is that one is one party die, the other party take over. So we put the parents' name, then one party die, the other party only have half. They won't inherit the whole house. Yeah.
So tenants in common.
Yeah, tenants in common. To prevent the whole house gone to next party. But we hope they're happy, so don't.
And I remember that if the one overland company name, then it's not applied for the dowry.
Yeah, it's not. Yeah, apply. So maybe I'm confused. I'm wrong with this. If it's company name, then no dowry right.
Okay.
And if it's investing, no dowry right.
Okay.
But it's not. It's not joint venture or it's not joint tenancy or tenancy. Yeah. Joint venture is for commercial use. Okay. If okay, let's go to B. Provide a complete dowry consent and acknowledgement. So there we have on the web form. I don't know if you guys check it. There's a dowry rights consent form, but dowry right consent form by then they sign it. We don't know if they do sign by themselves because can be the husband want to sell the house without the wife know he signed for them. So for that consent form, we want they go to lawyer and sign in front of lawyer to be legalized. Yeah, because for our digital signing, it's so easy to somebody else sign it. So we do sign that form. It's just for proof we verify this information in our end. But I don't think that one is legal. Yeah.
But we do need before we sign it, do we need to see the lawyer's document?
two ways. One is like, for example, like when we sign purchase contract, we don't have lawyer involved. When we sign listing contract, most of the time lawyer only involved before possession transaction. So, but if you want to be correct or you want to be safe, you can ask your client go to lawyer, sign dowry right consent form first, because that one lawyer will sign there to prove they are signing in front of them. That'll be more legalized. But normally we don't go to lawyer at this stage, right? Because when we're listing house, we don't ask them go to lawyer because spend money. A house may not sell. But what kind of case they need to go to lawyer before possession? One is dowry right. One is power attorney. Another way is power attorney. Power attorney means like if you might not be here. My cousin told me, okay, I want to put my house on the market, but I'm leaving next month and I won't be back. So how about if you sell my house on possession date? So I will tell them sign power attorney to anybody you trust, but your realtor cannot be your power attorney because we're agent. So you can, before we always hire like our other realtor's wife, spouse, because because when we were teens, we just use Lulu a lot. So because this person only has right to sign, but no right to access her account, his money. So it's actually quite safe. So you can entrust someone who stay here and willing to go to a lawyer to sign for you. And there are two types of power attorney. It's not on the contract, but I can explain to you. One type is general power attorney. General is really big power. He can sell for you, he can buy for you, he can open account. But right now, some banks don't reject. But general power attorney, you can do anything. So I got two general power attorney from my own sister and one of my teacher. They are overseas. They're at that time foreigner can buy a house. So most of the times I will sign a general power attorney if they are foreigner, because we can open account, we can go to the utility company, we can do anything for them. We can go to the bank. So that's called general power attorney. Another one is only one time. Like for example, you only leave this for selling this house. You put a particular power attorney, only this one house address and only buy or only sell. So that attorney only for one time thing. Okay. And so when they sign at the end, when we talk about signature, we will see two types. One is by power attorney, one is power right. Yeah. So it's better these two things go sign in front of lawyer. Yeah. So for this B, if seller fail to provide it, okay. If you are listing agent, you think you just use your dowry consent form. If the buyer really want to withdraw for any case, he can use this as an excuse, because even though this is not condition, but if you didn't provide them before which day, they can decide not to continue. So they may void this contract. Yeah. And give the seller written notice. For this case, if they didn't provide you a complete dowry right, that means legal dowry rights, they can use this reason to back up. Okay? Any question?
There's a written says that should be the legal document.
Yeah, but complete. I think complete dowry consent. Completed.
Yeah,
that means it's legal
Mm-hmm.
because that's contract. Now I think it's So you need a lawyer, not the one we by ourselves.
Yes.
So even though our contract is legal by realtor, both parties sign, but dowry rights, you need to go in front of lawyer and also power attorney. So that's why I mentioned about power attorney too.
And for the date, is there like general?
Yeah, most we put the appropriate date. I mean, to me, I just talked to Janice my case. Before I just use my own phone because I don't know if this deal will go through. I normally won't let my clients spend money before it's anything firm. If I trust, then I normally just use my realtor's phone.
Okay.
But it does never happen to us. People want to, but some realtor, they will request, we want the dowry right from lawyer. Then we will do that quickly to then go to lawyer. Yeah. So it's really people more aware of this case. Before we seldom ask, and now we see more and more people ask, you have a dowry consent form, can you send it to me? Normally, when they send to you, it's lawyer sign, it's not out by us. Okay. So let's go with the next one, 8.1. Angela, you want to read it?
Okay. The seller and the buyer will A, act reasonably and in good faith in trying to satisfy their own conditions, including making reasonable efforts to fulfill them, and B, pay for any cost related to their own conditions.
Okay, we can start here first. So conditions, very important. What's the difference between conditions and terms? Because we will see terms later. So who can answer me? Conditions. Okay, conditions is like if you don't remove conditions, it's because the third party, not you. For example, home inspection, it's not because of you don't want to buy, change mind. Or financing, because the bank reject you, it's not because you don't want to buy. So the third party, then we can put it as condition. That means it's not simply you change mind, okay? So it's not decided by you. So for regular, most general condition we'll see is financing, property inspection, sale of buyer's property. This one I will explain later. But what's the additional buyer's condition you normally can see? Who knows? Yeah. But it's not because of buyer's change mind. It's the third party.
Construction.
So,
Construction.
No. Normally, buyer's condition, if you put subject to legal advice, subject to you want to extra protect yourself. Maybe you want your lawyer to read it through, and that's your lawyer suggests you don't continue. Or when we say subject to legal advice or subject professional advice, then maybe including your accountant, if it's a commercial or something. But the more condition you put, the weaker, right? The weaker your offer. Yeah. So it depends on this market. If it's a seller's market, we need to put less condition, right? To get a bigger chance. Yes. But if you are buyer's market, actually you don't need to put too many, because one condition that's not removed is deal collapse, right? So financing is the most time we will put it in. If it's a really competing offer, like many compete seller's market, we sometimes will suggest our seller don't put the financial condition, but you still want to protect them by put on the term. Seller allow buyers, bank to come and do appraisal. Because if you don't put condition, some seller will just refuse any people coming after so. So actually, you don't put condition doesn't mean you don't need finance. You still need to borrow money, and banks still need to come and do appraisal. So if just for competing reason you don't put condition, put at a term. The seller will allow the buyer, the bank come and do the appraisal. Yeah. But if it's a normal situation, we will put a condition date for finance. You can put that no exceed how many percentage on or before. So that's also could be a reason to not remove if you say okay, not to exceed 25%. For example, 20%. Then the bank may request on buyer, okay, for your case, you need to put 35%. So even bank approve you, but because you put on a contract, so if it's over 20%, buyer can not waive the condition. So that's the reason you want to put it in. Understand? So if you say not exceed 20%, but when the case is the bank may request you to more, otherwise I won't qualify you. But if the buyer actually he has more money, but he decide, no, if you want request me put 25, 30, I decide I want to buy the house. If you put that in here, then you can non-waiver. Yeah, because people might say you should. The bank say you're qualified, and you don't waive the condition. I can sue you. Right? But bank qualified, yes, but they want more. So this is a chance you put it in. But normally we don't want to put to trigger more chance to withdraw, to back up. If you want to put a good or firm offer, okay. Right. Now they delete the interest rate. Before there's another policy, the interest rate don't over how much. Okay. And another way you put the down payment percentage is to show the seller how strong your offer. Okay, so if you leave it blank, as a seller, we don't know how much down payment you have. Maybe you're only 5%, and another offer is 50%,
yeah,
or 25%. I will choose the stronger one. So the reason you want to put it in, also you want to show the seller your client has a strong big down payment.
Yeah.
If they are 5%, you need to put it in 2. You need to let them know it's a high risk. If you just leave it and then come back, but that's your so as a seller, when we receive an offer, I will pay attention on here.
Okay.
Yeah, because if I see 5%, I may not want to sell to you. But if I only have one offer and I be on the market for long, then my next step, as a leasing agent, I'll call the buyer agent. Do they have a pre-qualified letter?
Mm-hmm.
If they have, can you send me? So I got double check. Yeah, because some new agent, they don't know, they don't even ask. Whoever tell them I want to buy a house, then they start showing. Maybe they just skim or something. Right. Okay, yeah. So percentage is when we look at offer, we really care about the percentage, because over 20%, you are safe. You don't need to go through CMHC. Right. If it's under 20%, you will pay a one-time fee for CMHC. The rate percentage is different, but you will pay a one-time fee. Could be like a couple thousand to, yeah. That's mean you're kind of high risk. But lots of local Western people, they do really low down payment. Yeah. Because they don't save money, but they can qualify because they might have a really high salary income. So it's not necessary 5%. Yeah. It's bad. Right. We like to see higher. The higher, the safer, because the buyer doesn't want to lose the down payment. But they won't. But they'll lose the deposit. Yeah. Yeah. Okay. So on or before which date? Normally, for a regular financing loan, we give them 1 week to 10 days business day. So we don't count the weekend. So Monday to Friday, 5 days. So we actually put 2 weeks, around 2 weeks range is a normal financial condition date. But when I say normal, it's like if you are competing, and if your clients say, I still want to put the financial condition, you can try to make it shorter, maybe a week, and push the bank to do it fast, rush them to do the faster. And home inspection, public home inspection, like I mentioned, home inspection maybe just one afternoon will be done. And normally the home inspector now they give you a report really quick before, not that convenient, maybe wait for 2 to 3 days. Now it's the same day report. But why we don't want to do home inspection right away?
It's cost money.
Yeah, it's cost money and maybe their financing won't be approved.
Yes.
So when we put 2 weeks to 10 business days, normally people will book home inspection at the very late, before completion day.
Okay.
The reason is we want to confirm they got the mortgage approved first, and then we book the home inspection.
Yeah. But
yeah.
you can always book the inspection earlier, but put
yes.
the date
yes.
late.
I mentioned that last time.
Yes.
Yeah. So, but on the condition day, normally we like to put it at the same day. This is not rule or regulation, but it makes safe your remember less.
Right.
Like don't
Multiple
remember
days.
so many
Yes.
multiple days to remove condition. So even though home inspection only 1 day, if we have financial condition, we'll put the same condition day.
Okay.
We put the same condition day. But if you don't put financial condition, maybe seller will request you shorter because home inspection only need 2 to 3 days.
Yeah.
Why you give me a 10 business day? Yeah, since you don't have financial condition. Okay. C, sale of buyer's home. This is more complicated one. That means the buyer put the offer, but they still need to sell their home to get a down payment. So when you put sale of buyer's home, most of the time, seller don't like it because you put your burden on them.
It's not secure.
But when will we take it? When it's buyer's market, or when this house is on the market for long, 3 months, didn't sell. Yes, we'll take it, but seller can still marketing on the market for sale. So only this chance you can continue sell. Other you have to change to pending. But sale of buyer's home, you have to disclose on the remarks say this house is subject to sale of buyer's home. And normally at this one, we will put a date because we don't wait for you forever. How long we can negotiate? Like wait for you 30 days, 60 days? Most of the time 60 days. We wait for you to sell your house because there's a case the house may be hard to sell.
Yeah.
Then we can wait, but we can still marketing on the market. Okay. So how happen if your conditions subject to we call this special class offer. That's mean when another offer comes in and you have a sale of a buyer's home condition, we normally give you 72 hours special class offer. We put the offer. We will put on the remark say there's a special class offer in effect. That's mean the buyer will need to sell their home. And if I'm the next buyer, I put the offer, you accept my price. We give the first buyer 3 days, 2 to 3 days, depends on the offer how.
To sell the property? That's really
to decide.
Or to decide.
To decide you want to remove condition or you want to non-waiver, waiver or non-waiver. So the 72 hours is our stand. It's most of the time people use that. But if you can negotiate at your first offer, because the first buyer maybe say you give me 1 week notice with no 48 hours, then no 72. So, but 72 is the most common days for 3 days. So that's mean I give you 3 days. If you really like my house, then you take your own risk.
Yeah.
Right. If you cannot because you simply no down payment, then you give up. Then I can sell to next person.
So for this kind of thing, does the buyer need to approve like the value of their house they're selling?
Normally on the contract, this purchase contract, right? If you put on the additional buyer's condition, in here we will write down the buyer's address. And we will say, we will prove to them we will be on the market. We already signed with our agent. If you accept my offer, my house will be on the market by which date. And I will sell to which price, and the seller agent and seller can consider if it's reasonable.
Okay.
Like we did accept one kind of this offer, then I will check the property and I confirm that's this customer's property, and I confirm their asking price is right,
Okay.
then we'll accept it. If they put a ridiculous price, we won't accept it.
Yeah, because they don't want to sell.
Yeah.
For real.
Yeah, so they need to put their address here,
Nice.
and they even maybe need to attach their listing contract to show us if this house be, because that's a buyer, they don't want to sell the house till they find the house they like. But this will make it more difficult to let seller accept. But some buyers, they are really, really conservative. They don't want to any risk. So they have to buy the house, then they sell their house. Or some people want to sell their house, then they buy their house. But most of the time, I would suggest my client do this. I mean, depends on their financial background. If they have enough down payment, we don't care. We just buy first and then sell. Or also depends on market. Like current market, if I know the market is still going up, I would suggest them buy first and sell later. Yeah, because if you buy later, the house goes higher and higher. But you buy first and sell later, then you can have quickly sell your house and get the down payment, or you can do bridge finance. Bridge finance, you pay higher interest rate, but it's a short term to after you sell your house. Right?
And how long bridge loan will last?
Bridge loan really depends on you and bank because they charge you interest. They don't care if you're willing to pay longer.
Okay. Several months.
Doesn't matter. I mean, most buyer, like my buyer won't do that because they normally have enough money, or they normally feel safe to buy first and then sell. Yeah. Because if you don't have enough money, you buy first and you sell, you will end up sell lower too. So some people don't like it. Yeah. So most people will sell first and buy. And safer. And you can decide how you want to sell. Because if you want to sell higher, you might need longer, right?
Yes. Yeah. So as a seller's agent, do we need to check the buyers selling the property, but it may be on some like mortgage, right? So after maybe he has some mortgage on the bank. So after getting money, he has to pay the bank first. And
lawyer will do that.
But do we need to verify the mortgage amount?
The best way is verify the mortgage. It's on the listing contract list.
So
but when do you want to verify? Well, if they have really high mortgage, higher than or close to your asking price,
right?
Like last time I mentioned, then you might have chance they don't have money to pay your commission. Yeah. So at that time, you want them to send you a mortgage statement.
Okay.
But when we'll see they might have a risk, if you pull out land title, you see CIBC how much amount. And if you appraise on the current house price, if you see that amount and the price is quite close, then you ask them give you the mortgage statement. Because you don't know, some seller they may be prepaid. So even though on the title it looks quite high, but they may be every year they can pay 15%. So it doesn't mean they're high, they are in danger. You just need to verify.
And same for the financial, because do we need to
finance?
Do we need to verify the saving or the bank statement for them to be able to pay the down payment?
This is a buyer. This is a purchase contract, and you know what? This is not our job because most customer will feel that's their privacy. They don't want to show you. So
you just have to trust them.
That's no, not just trust. We want them to talk to broker, mortgage broker. I normally when customer come, I will ask, did you talk to your mortgage broker? If they say I don't have any, I will refer them when. Talk to them first. And then they understand how much they can buy, and they understand they have to qualify. Right. If you want to approve, you ask the mortgage broker give you pre-approval letter. Because if you ask your customer give you a statement, they will feel not comfortable. That's their privacy. You're only the realtor.
So always third parties.
Use as a mortgage broker. So if you talk to mortgage broker, if they told you yes, we talk to mortgage broker, can you send me a pre-approved letter?
Yes.
But normally I'm the one who arranged the broker, and my broker will let me know. So we don't want to running around and find out they can even qualify.
Yeah.
Then you're not professional, because the other party will be mad too. So even financial condition backup market, most of the time actually it's a buyer change. Because for me, if I put the offer, I only put the offer I know they qualify. But if they change mind, they use this as an excuse.
Okay.
But if they do not qualify and you put the offer, that's mean you are not professional enough. Yeah. So that's why when you are low in the market, why some realtor they prefer deal with couple realtor, because they know you always qualify your customer. If you always backup market many times, your name is not there. They know you don't do your homework, you don't do your job. So if my customer, if there's a competing offer, it's many times competing offer, listing agents suggest their owners take a Vivian's offer, because they say Vivian's always obey their words. That's important, because when you put the offer, you know they can. They won't just withdraw and suddenly find out they're not qualified. That's really unprofessional. Yeah. But yeah, there's a case, customer change mind, customer sleep one night and cold feet. Then this is a chance to use the reason. But banker, they don't want to write a fake letter for you. Yeah. So for property inspection, this one is more easier to withdraw, because in the long time ago, we have to put this on the contract, we have to the problem have to be more than 10% of the purchase price, because there's so many arguing like about one light bulb broke, I don't want it, like small thing, because they just change mind.
Yes.
And then after a couple of years, it changed back to they don't put the dollar amount, because they think the buyer has right not to buy it if they feel anything like. So right now, public inspection, I would say right now, because maybe they will discuss and change the rule again. I don't know, because I've been so many years when we see the trend. There's a time they say you have to over 10%. There's a time now it's like you don't give any reason. Like if you don't want to remove, just don't remove, no reason. And before there's a time you have to show the seller you do the home inspection. Now you don't need to, but they probably will challenge you, because if you don't even come and do home inspection and you say home inspection not approved, then they will challenge you. Yeah, they probably say you are changing mind. We don't want to return your deposit. So, in case your people really don't want to buy it, change mind, and they put financial condition, then you go and do property inspection. It's recording, but I want to say one thing is my client changed mind, and we just call it just my husband go and do inspection and make a report. Because home inspection no need license. So then yeah, home inspection no need license. There's no
license for the detached house, but for the condo it's no need license.
Oh, condo document
no
reading. I'm sorry,
yeah.
But home inspection actually here it doesn't say you have to hire professional home inspector. It could be yourself.
Okay.
Because on the contrary, oh no, now it's a license. Oh, okay, now you change. Sorry, you have to conduct by a licensed home inspector. Yeah, but before at our time, early time, it doesn't need license. Okay. Yeah, so some people just hire their friends, go and check the furnace and hot water tank, and make a report. Say they want.
So for the condo
document, yeah,
no need to hire the licensed home inspector. Sale
of buyer's property, we mentioned that where I come back. Okay, wait, I jump and come back. Yeah. Okay.
Okay.
Okay, 8.3 seller's condition. So when will we have seller condition? Yeah, nowadays the most chances backup offer, because if seller accept an offer, next person want to put the offer, and it happened a lot this day. And last year, this year, I put lots of backup offer. Don't be afraid to put backup offer. There's a huge chance you'll get it, because there's an offer, and most people give up. Then go to shopping around the houses. But if the first offer backup market, you got the first right. If they go back to open market, maybe it's competing again. But if they accept your backup offer, then you don't need to compete with other people. So for that example, you be like Jim's condo, you should put a backup offer. So when it's backup market, it's yours, right? So you don't need to go back to open market and compete again. So backup offer is like conditional sold. You still have a chance to put the offer for your buyer. Then you put on seller condition, because this seller need to remove the condition. So subject to seller's first contract, put the contract number, because every contract, right, upper side there's a contract number. This contract collapse or not continue or not firm on or before their condition date. So if you want to put the backup offer, first ask the seller, what's your contract number? Second, ask them their condition date. And you don't want to be on or before the condition. You don't want to be too late. You want the same day. Because if they are removed condition date 9 p.m., then you put your 10 or 11 p.m. So if that one doesn't go through, default to you. If you put too many days, I mean, I don't know what happened, but we normally put first day, same day, yeah. So after the condition, seller remove, then your contract became legal. Yeah. So normally seller condition will be earlier than your condition. You want your seller remove condition first, then you remove your condition. So if you put there, for example, 20, just randomly May 20, then you want to put yours May 25 or May something. But since you're waiting, if it's a condo, this one is not condominium. Normally, we're waiting for backup offer. If it's condo, I won't put condominium condition document reading no more. I will ask the seller, give me the document. I can, during the waiting time, I can let the buyer go through the condo document first. Then your offer will be more firm. You have a less condition. So they got more chance to get it. Okay.
Sorry. So you say as a buyer's agent, you will suggest the buyer. I mean, if the house is a convenience sold, you will suggest the buyer to put a backup offer.
If they really like it.
If they really like it, and then the date will be later than the
seller's first offer's condition.
First offer condition, right?
Yeah. But you can do something during this time. You don't need to wait till they remove. Then you start read the condo document or start do the financing. Okay. So while waiting, you do the thing, no spend money, like get the approval, no need money. Read condo document, maybe need money, but you get the documents. Right. Go through that first, right?
But you just said as a buyer's, the buyer's condition normally will be later than the seller's condition.
Right, because you remove your condition. If seller didn't remove, you are in the risk. I mean, not in the risk. It doesn't make sense because you don't want to do another home inspection during the house is still pending. Right, because the first buyer has a big chance to continue to purchase this house. Right. So I say do the thing. No need to spend money first. So don't do home inspection. But you can do other things like bank qualify for you. You won't spend your money. Yeah. So you save time, and you only do home inspection after they remove condition. So maybe one day you can remove condition. That will make the seller willing to take your backup offer. If your price looks attractive and if your condition is attractive, then they will take a better offer. Otherwise, if like current market, they would rather the better market and compete again. So only if your better offer show less condition and acceptable price. Yeah. But for better offer, I won't starting with increase listing price because nobody compete with you. So still bargain a little bit, and they will counter you if they think you're too low. But if they feel actually you're similar first offer, they will accept. So don't presume better offer you need to increase price because you're not competing with anyone. You just get the first right. If the first one doesn't go through, it go to you. But better offer, if they sign, you still need to put a deposit within 3 days. It's not like just because no deposit, no contract, you can legal.
So how many backup seller and backup of a seller can accept? Just one?
No.
Can be multiple?
There's a chance I heard they have received 3 backup offer. So the realtor said, if you want to put a backup offer, you are the second backup, you're the third backup.
Okay. So it could be more. There's no limit, right?
No limits. It's just like people who are at the third, do they still want to try?
Okay.
And also during backup offer, you can still change mind. Like if this conditional sold for 10 days, condition day, and you put a backup offer the second day, but during these 10 days, you find another thing, you can put the non-waiver. Because you have a condition, right? You put the non-waiver, then you can withdraw. So it's quite safe.
So the deposit will.
Yeah, because there's so many conditions. Any condition not meet, your deposit will be back. So condition is because it's not decided by you, right? It's not decided by you, so you can withdraw. Of course, you won't say because I find another house. You will say financing condition or anything because seller didn't remove the condition yet anyway. Okay, let's finish 8.4 and there's no more. Okay, let's finish 8.4. Do we have more for 8 and 9?
8.4.
Oh, you're done. Okay, 8.4. Then we'll finish today. Okay, condition notice. Okay, well, Janice, you read it.
Each party will give the other written notice that A, a commission is unilaterally waived or satisfies or more before this condition date. If not, this contract will end after the time indicated for that condition date. Or B, a condition will not be waived or satisfied prior to this condition date. This contract will end upon that notice being given.
Yeah. So if you don't sign the waiver on the condition date, this contract dies. Even you didn't send the non-waiver. But we prefer people still send us non-waiver in writing because it's more like responsible. If you don't do anything and then you die, people feel not comfortable because you didn't even give me a notice. But based on A, you don't have to. You just let the time, like if you write 9 p.m. is your condition day. For example, on today is which day? Like
21st.
Yeah, May 21st, 9 p.m. After 9 p.m., if you didn't receive waiver, this deal is back. But could be they forgot, could be they didn't pay attention. So call first why there's no waiver. If both parties, oh sorry, we forgot, or my client is too busy, then both parties need to sign amendment to agree to extend. But if nobody they didn't sign, then this deal die. Deposit go back, even no reason, because this deal doesn't. But deposit go back doesn't mean seller let you go. They can go and sue you if you didn't give them any reason. Okay. But it's based on this contract, it's collapsed, and we have to return deposit. Company brokerage cannot say, okay, call the brokerage, hold the deposit, don't return because they didn't give us reason. Based on contract, we have to return.
Right.
And you go to the court to ask for your loss. Yeah, that's two separate things. Or a condition will not be waived or satisfied. So you can waive on the condition day or before condition day. So normally for my client, if they do change mind, I don't want to hold for 10 days because I feel that's not good for seller. Let them know right away. We don't say they change mind. It happened to me twice last month. We conditional, so I'm the seller. Next day they say the buyer finance didn't go through. We know it's an excuse, but it's on the contract. So we just don't say anything, let it go. Yeah. So normally that the other party go right away because we don't want to let them wasting their time and wait till last day and didn't tell me and let the time pass by. Then you will become the person that we just don't want to deal with you next time. So be responsible, be cooperate with and think about other party. If they sell to you, if your client don't want to buy no more, let them know next day and find a reason because there's a reason. Even though we all know it's not a real reason, but based on contract, we cannot say anything. We let it go.
Okay, so now, if we combine with the deposit part and with section 3 or 4, so there's also a condition day for the deposit for 10 days.
You mean which one?
The section 3, like all the way up. So, so when we sign this contract, no deposit has been made. No deposit. No,
you still need to.
Right.
So the condition is not seller give you deposit, right? It's a buyer. Seller put a condition. They have to remove their seller. Other than this condition, some seller just say they want their legal advice too, or they want they have other. That's backup offer, not the only one.
Yeah, no, yeah, I'm not talking about backup right now. I mean, because there's so many dates in this contract. And condition days, sales condition, buyer's condition, and there's a deposit deadline.
Deposit is not based on condition day. It's based on you sign the contract and you need to put the deposit within 3 days.
Oh, within.
It's not condition day.
Right.
Condition day is just for pending to sell.
Yeah, I mean this whole contract. When we signed this contract, the deposit was not made yet.
Not made yet, but you need to. In the old time, I say old time because at that time we don't have a DocuSign. When we present offer, we normally take the deposit check with us.
Yeah, when
that's
they
the
sign.
old time.
Or when they sign right away.
Yeah.
Okay.
Yeah.
But now they have 3 days.
Now it's DocuSign. Nobody really go in person present. So we will sign and then we ask them wire the deposit or send the deposit to our office.
Yeah, but they still have like several days. I remember there was like 10 days.
No, 3 days.
3 days. Okay.
If you need to more than 3 days, put it on the contract because if we don't, there's a place we have to put down how many the here deposit.
Section 4.
4?
Yeah. 4.
Yeah. So you have to put. Normally we put 3 business days.
Okay.
Business day. You can put if it's a Friday night, you don't count Saturday, Sunday, and you till next week. But if we put, your buyer say, okay, our money we need more day, then we can extend or put it at the beginning. We need more day. But when I see, if I represent seller, when I see over 3 days, I will be cautious. What happened? Why you need that many days to put the deposit? Give yourself a longer day to change mind. Yeah. Okay.
But still, I mean, obviously, even if they pay the deposit, they can still walk away with conditions.
If they have a condition, they can walk away. If they put a no condition offer, and if both parties say this contract is legally binding, yeah.
So deposit is not refundable.
If they didn't put deposit yet, it happened to us. Lots of buyers still change mind.
Even if non-conditional.
Yeah, But at that time, most of the time, seller will say, I'm going to talk to my lawyer because you are changing mind. Depends on the seller, they want to influence. Most of times, competing offer. If you put really high offer, we choose you and you change mind, they will go to lawyer
before the deposit.
Okay. But I mean, for this year, I believe that's of this happen. People maybe just go ahead, look forward. I don't want to waste time to deal with you. Sell higher, right? Next week, sell higher.
Yeah.
Okay. Today, so next Tuesday, no training. No training. Sorry, it's a Charles. Charles, I will be Monday because I need to go to Clermont on Tuesday. Yes. Thank you. Okay. So today, what's within